Hello and welcome to Triage, timely conversations for healthcare professionals, a podcast created and produced by K&L Gates. Each episode is designed to highlight important developments in health law and analyze the impact on our clients and friends of the firm. We hope you enjoy this podcast.
And thanks everyone for joining today. I am Steve Pine, a health law partner in the Research Triangle Park office of K&L Gates. And I'm joined today by my colleague and fellow RTP health law partner, Gary Qualls. And today we're going to be talking about the Federal No Surprises Act and some recent developments out of a federal court in Texas that are poised to shake up a key arbitration provision within the act. And so for Gary and I, as attorneys in the payer-provider disputes litigation space, this is all very near and dear to our hearts. And I think maybe a good starting place here, maybe a very quick refresher on the No Surprises Act to help orient folks to where we are today. Okay, so the Act was enacted more than a year ago now, in late December 2020, and it includes a number of provisions that are aimed to protect patients from being hit with so-called surprise medical bills in certain circumstances when they unexpectedly find themselves receiving care in an out-of-network setting. So in particular, there's several emergency and non-emergency categories of care that the No Surprises Act covers. This includes emergency services that are received at an out-of-network facility, which would include facility fees, as well as both emergency and non-emergency services rendered by an out-of-network provider that is operating within an in-network facility. And then it also covers both emergency and non-emergency services provided by out-of-network air ambulances, although no ground ambulances are not covered by the Act. So, for example, patients might receive a surprise bill from a non-emergency out-of-network provider of ancillary services, such as an anesthesiologist or a radiologist, or by a specialist, such as a cardiologist, that, again, are providing services within an in-network hospital. So when patients find themselves in these settings, the No Surprises Act does a couple things. One, it provides the patient with a number of patient protections. These include things such as prior authorization protections, coverage limits, cost-sharing obligation limitations, and limitations to out-of-pocket maximums. And so the developments we're going to be talking about today don't impact these patient protections. But another key provision within the Act is what we tend to call the arbitration provision, or officially it's the Federal Independent Dispute Resolution Process. And so this is the new federal process that was created under the Act to resolve disputes between providers and payers as to the appropriate payment rate for services that are provided in these surprise out-of-network settings. And while we don't have time today to go into the full details concerning this arbitration provision and how it works, what we will do, we'll link in the materials provided with this podcast, links to a few different alerts that Gary and I have published that walk through how the arbitration process works, when it does and when it does not apply, as well as some tips and traps for navigating it. But in brief, this arbitration process is a fairly novel baseball-style arbitration, which means each party to the arbitration will offer a single payment amount that they offer to resolve the dispute, and then the arbitrator has to select one amount or the other with no ability to split the difference or arrive at any other conclusion. So how these arbitrators, or certified IDR entities as they're called under the Act, how they are required under the Act to make that choice between the two offers. This is where this controversy has arisen. So the Act specifies a variety of factors for arbitrators to consider, and some they're barred from considering in order to make this decision. These include factors such as the level of training or experience of the provider or the facility, quality and outcome measurements, market share, patient acuity, complexity of services provided, teaching status, case mix, and scope of services at the facility, good faith efforts or lack of good faith efforts to join the particular payer's network, prior contracted rates between that payer and provider over the previous 4 years, and then this concept called the qualifying payment amount. And so the qualifying payment amount is the heart of this controversy. So Gary, could you explain what is a qualifying payment amount and why has this caused a controversy?
Sure, Steve. The QPA is essentially the payer's median contracted rate as calculated per a methodology in the rules. So in the July interim final rules, and I'll call those the July rules, the agencies explain that the QPA will generally be a payer's median in-network rate for similarly situated services. In other words, the payer's median in-network rate for the same or similar services furnished in the same or similar facility by a provider of the same or similar specialty and in the same or similar geographic area. Now, an interesting note about this is the calculation of the median rate was to be based on the payer's rates as of January 31, 2019. They set this in stone in time, and then they adjusted forward for inflation. So let's fast forward then to the QPA presumption in the October rules. The July rules defined the QPA. Then the October rules, which were controversial and were at issue and are at issue in the cases Steve and I will describe. What happened there was the October rules were the context in which the agencies detailed the mechanics of the federal IDR process. But recall that the Act had already established multiple factors that an arbitrator shall consider before the rules were promulgated. Those were the items that Steve just mentioned. So the Act had already established the mechanics with respect to the factors that the arbitrator must consider. The October rule established the QPA as the presumptive reimbursement amount for arbitrators to select, or for the arbitrators to select the amount closest to, the offer closest to that amount. Now, for providers, this came out of nowhere. And essentially, what this October rule said was that the arbitrator must select the baseball offer that's closest to the QPA unless the presumption in the QPA's favor was rebutted by credible evidence that the QPA would be inappropriate under the circumstances. And how would the arbitrator determine that it's inappropriate under the circumstances? They would look to the other factors. This raised immediate concerns by providers for numerous reasons, one of which was that the providers felt that the agencies had improperly given this priority status to the QPA and unfairly or improperly advantaged payers in a way that was just simply not contemplated by Congress. The next step in the process here was this Texas case that was filed in federal district court in the Eastern District of Texas. That is one of numerous cases currently pending, but was the first to be decided. In that case, the plaintiffs, the Texas Medical Association, had challenged the October rule QPA presumption under a couple of different grounds, one of which was that the rule was inconsistent with the statute because the presumptive QPA was not what Congress had envisioned. And secondly, the rule was issued without the Administrative Procedure Act's required notice and comment. Now, the latter point is less important because the agencies could have just corrected that piece of it. The more important part was the challenge that the rules were inconsistent with the statute. So here's what the Texas court essentially ruled. The Texas court ruled that the October rule and the QPA presumption was in fact inconsistent with the NSA, with the Act's own language and the way that the Act had set up the factors. The court, first of all, pointed out that the Act's mandatory language of shall plainly requires the arbitrators to consider all of the factors that Steve had enumerated that were in the Act. Moreover, the court pointed out that there was nothing in the Act that instructed arbitrators to weigh one factor more heavily than others. The Act nowhere stated that the QPA was the primary or most important factor, nor does the Act impose a rebuttable presumption to select the offer that's closest to the QPA. So the court concluded that, as the providers had argued, that the October rule unfairly or improperly placed its thumb on the scale for the QPA, requiring arbitrators to presume the correctness of the QPA. That was not in the statute. and then imposing a heightened burden on the remaining statutory factors to overcome that presumption. There were a few things that the court said importantly in the context of rejecting the agency's arguments. First of all, the agencies had claimed that somehow the overall statutory scheme of the NSA supported this presumption in the rule. But the court pointed out that the agencies cite no authority that a statutory factor is entitled to more weight simply because it's the first in the list. The court pointed out that if Congress had wanted to restrict the arbitrator's discretion and limit how they could consider the other factors, it would have said so. And the court pointed out that that is particularly the case here, where Congress described the arbitration process in meticulous detail. Even though Congress left many of the procedures for the agencies to fill in the interstices, that was not the case with the factors, again, that the Act set forth very specifically. So the court held that the rule impermissibly rewrites statutory language by ascribing additional material terms that were not in the statute. And the court also called out the agencies in terms of the at least implied admissions that the agencies had made when they were announcing the rules. The court said the agencies themselves repeatedly touted the rule as establishing a rebuttable presumption in favor of the QPA when they presented the rule for public viewing. That is undoubtedly why the agencies argued to the court, so said the court, that vacating the rule would result in higher reimbursement payments to providers, would be highly disruptive to insurance companies, and would upend efforts to control upward pressure on healthcare costs. The court viewed it that the agencies would not be making these arguments if the rule were simply implementing the statute's terms. So that is kind of the essence of why the QPA is so important and how the Texas court order impacted the QPA and the arbitrator's decision-making process under the NSA.
And for the fellow administrative law wonks listening in, I thought it was kind of interesting as well. You know, the court applied its traditional two-step Chevron analysis here, but really never got past Chevron step one. You know, the court held that the No Surprises Act was unambiguous in putting the QPA on equal footing with the other factors listed, and so never needed to get to Chevron step two to determine whether the department's interpretation was a reasonable interpretation of an ambiguous statute, because it found that the statute was unambiguous. So I thought that was interesting. Now, so in terms of remedy, what the court did here was vacate just the specific portions of the rule that dealt with the QPA presumption. So the court did not vacate the October final rule in its entirety, just the portion that dealt with the QPA presumption. So, importantly, the IDR process remains in effect today, but the revised language no longer requires the IDR entity to select the offer closest to the QPA, nor does it establish the QPA as the presumptive out-of-network rate. So, this was a big win for providers, and it appears for at least the time being, CMS is going to acquiesce to the Texas court's ruling in ongoing IDR disputes while it evaluates whether to appeal and while it awaits decisions really in numerous other federal courts. We know this because CMS issued a memorandum on February 28th, 2022, that referenced this Texas court decision, acknowledged that the departments were reviewing the court decision and were considering next steps, but that for the time being would adapt the IDR process to conform with the decision, that the departments would withdraw their prior guidance on the QPA presumption, would provide training to certified IDR entities on this Texas court decision, and would be continuing with the IDR process. So, Gary, I think a lot still could change in the near future as the departments potentially appeal this decision and as we await decisions in these other federal cases.
I think it'll be fascinating to watch how these other courts come out on some of these similar arguments.
Well, I think that's about all the time we have for today. Some real fascinating developments and a lot more still to come. Thanks, everyone, for joining us today, and hope everyone has a great week.
Thanks again for listening to Triage. timely conversations for healthcare professionals. New episodes are available for download through Apple Podcasts, Google Podcasts, and Spotify. By subscribing to Triage, you will receive timely notifications for each new episode. Also, if you have any topics you would like to hear discussed on Triage, please don't hesitate to email triagesupport@klgates.com. We would love to hear from you.